Good evening, everyone. Thank you for joining us. We'll be starting in 5 minutes. We thank you for your precious time and the patience here. We are waiting for a few more people and then we'll join.
लेकिन कोई देख भी तो नहीं रहे।
Hello, and a very warm welcome to everyone. Thank you for joining us on a rainy afternoon, rather a cold one, I would say. If people have joined from outside Delhi NCR, then we would like to inform you it's quite rainy here. Thank you for joining us today. We are delighted to have you with us for our webinar on Digital Personal Data Protection Rules 2025, Transforming Cybersecurity and Privacy Compliance in India. I am Ishana Dubey, and I'll be your host for today's session. The webinar is designed to provide a clear, practical, and actionable understanding of India's Digital Personal Data Protection Rules 2025 and what organizations need to do to ensure compliance in this evolving regulatory landscape. So, the agenda for today is as follows. Introduction and context. Overview of the DPDP Act and the 2025 rules. Key updates introduced in the new 2025 rules. Roles and obligations of data fiduciaries, data processors, and consent managers. Key operational requirements. Governance and enforcement framework. Strategic implications for businesses. Roadmap to ensure compliance with the Act and its rules. How Cyber SRC helps you comply immediately. Open forum will be there for Q&A and discussion. We are glad to have with us Ms. Suhasini Sharma and Mr. Devanshu Pandey. We look forward to their valuable insights and practical perspectives of navigating the DPDPA rules 2025 and implementing effective privacy and compliance frameworks. Before we begin, a few quick reminders. Please keep your microphone muted during the session. You may post your questions in the chat box at any time. We'll address them during the Q&A segment. We encourage you to actively engage and share your thoughts throughout the session in the chat box and whenever there is a brief pause between the session. With that, let's begin the session. So I see there is a issue with the screen presentation. Give me 2 minutes. We'll sort it out, and you'll be able to see the screen. I would request I would request everyone to kindly give a go ahead so that we can confirm that the screen is visible to you. If you could please raise your hands. Okay, okay. So Suhasini ma'am and Divyanshu, it's over to you now. Thank you so much, everyone.
Thank you so much, Ishana, for the warm welcome. Good afternoon, everyone, and welcome to this session on India's Digital Personal Data Protection Act 2023, along with the Rules 2025. This law fundamentally changes how organizations in India and those dealing with Indian data must think about privacy first, second, data governance, third, risk and accountability. So, DPDP is not just a legal or compliance topic, it is a business risk, trust, brand, and operational transformational topic. So, today's session is designed to simplify this journey from understanding why DPDP exists to how you can practically implement it in your organization. DPDP is equivalent to India's GDPR moment, yeah. So it applies to any entity processing digital personal data. Penalties associated to it, board accountability, breach reporting, consent, and purpose limitation, etc. Before we go deeper, let me quickly introduce who are we and why CyberSRC is uniquely positioned to guide this journey. CyberSRC is a certain and STQC empaneled organization. We are working with regulated enterprises across BFSI, FinTech, manufacturing, energy, government, and SaaS ecosystems. We have experience across cybersecurity, data governance and privacy, IT audit, risk and compliance. We are ISO 27001 SOC 2 certified with a collective team experience of 45 plus years. We work across DPDP, RBS, AB, certain regulations, ISO standards 27001 to 27701, 42001, etc. Let's now explain how this workshop is structured and what you will get from it. It is a high impact 4 phase workshop. How we will explain it? Phase one, we realize that DPDP cannot be taught in one legal session or one IT session. It needs a business, legal, IT governance view. So phase one, in the reimaging privacy, we will talk about the evolution story. Where we would understand how privacy has transformed I'm talking about globally and how DPDP came into picture and what was DPDP's evolution story. Phase two would be the comprehensive reading session on DPDP rules, particularly covering the sessions that covers the storyline where we all know that it needs to be practically implemented in the organization within 18 months. So what was the storyline, like how the things needs to be done immediately within 1 year and within 18 months. So a reading session by Divyanshu would be taken in the phase two. Then phase three, again, I'll come into picture where I'll comprehensively tell that how cyber SRC can help you with the gap assessment and readiness analysis, identifying the gaps, risks, and key action areas, developing policies and processes controls around the deployment and how to execute the remediation activities in practical. We will where we'll be covering a high level glimpse of the manual plus automated approach in discovering the PII data, consent workflows. Final compliance review, verifying controls, assess manage maturity, and confirming the readiness for the DPDP compliance. So this will cover in the phase three, and finally in phase four, the Q&A session is open to all. Now, coming into the picture, the to understand why laws like DPDP even exist, we need to understand how privacy evolved. So this slide talks about the global evolution of the data privacy and the regulations. Privacy regulation did not start with GDPR or DPDP. It started when computers started storing human information. So in 1960 till 1980, OECD principles came into picture, concepts like data minimization, purpose limitation, accountability. Key point is the principles introduced, the concepts introduced. Now in 1990 to 2000, the directives, EU data protection directives came into picture. Data Protection Act, privacy became law, not just policy, but not globally, right? Now, the evolution came in the next decade, 2000 to 2010. HIPAA, PIPEDA, Australian Privacy Act, covering healthcare industry, fintech industry.
ये जो फाइल किसको भेजना है? तुमने शेयर भी नहीं किया,
I
फॉरवर्ड
would
किया?
request the participants to be on mute.
हाँ,
So it is a request to for all the participants to be on the
शेयर
mute.
किया तो मुझे रिटर्न आता था। हाँ, भाई दो टाइप का ना, एक तो फाइल डायरेक्ट तो मुझे भेजना है, एक होता शेयर्ड होता तो उसके। हाँ, नहीं नहीं, मुझे डायरेक्ट फाइल भेजा है वो, उसने शेयर नहीं किया। किया मैं करके मैं रिटर्न कर लेता था ना। तो किसको भेजूं मैं? मेरा
It was
नेक्स्ट
the
हुआ
ethical ask to be on mute.
नहीं है, तो इसने सीधा मुझे ही
Shana,
भेजा है।
all everyone. I think people are working parallelly in listening to this session. That's okay. But kindly be on mute.
मैं भेज दूं मैं करके? ठीक।
Swasti ma'am, we can continue.
Thank you so much. Yeah. So I was talking like global standards, global frameworks, HIPAA, PIPEDA, Australian Privacy Act. They came into picture between 2000 to 2010. Then after few years in 2015 to 2017, between this period, GDPR changed everything. Heavy penalties, breach notifications, consent, data subject rights, they came into picture. And countries copying GDPR model, Brazil covering the LGBT, right, PDPL UAE with respect to UAE, CCPA, CPRA considering California's aspect, and India DPDP. So between 2017 to 2015, global trends they came into picture. They being recognized, privacy being recognized as a fundamental right, right, globally. Okay, so in slide 5, we'll be covering the milestones in India's DPDP evolution. After that, we'll be heading towards the reading session where we'll be covering the important rules to understand. So Divyanshu will take up from there. So let's talk about the DPDP evaluation. So in 2000 to 2008, IT Act 2000 recognized digital data. Section 43 introduced liability. 2010 to 2011 SPDI rules, first privacy-like framework, consent, privacy policy safeguards, they came into picture. Between 2016 to 2018, Supreme Court declarations that privacy is a fundamental right, and then the multiple drafts, joint parliamentary committees set up, and GDPR-like thinking being adopted at that time. During 2023 to 2025, DPDP Act passed in August 2023, and then rules get notified in 2025. Now, organizations have 18 months to comply. So far, we understood why privacy law exists, how India signed at DPDP. Now, the real question is, what do you need to do in your organization? So, definitely, phase-wise consulting approach, internal gap assessments that needs to be done at the organizational level to understand your organization security posture as well as the privacy framework that needs to be adopted with respect to DPDP. So before going to that, I would like Divyanshu walk through us the important rules where the organizations need to focus on the basis of the immediate actions. The actions needs to be taken within 1 year and 18 months. So over to you, Divyanshu.
Yeah, thank you, ma'am. Thank you for such a detailed explanation on DPDPA. So, good afternoon, everyone. Let me share you my screen where we will be discussing the rules that have been introduced in the main gadget introduced in the on 13th November 2025. So, yeah. So, but before starting our reading session, I like to highlight few points here. Like we will cover the rules in three phases based on their implementation timeline. As man mentioned, it's based on the implementation timeline. The rule number from 1 to 21 set come into force on the date of the publication of the official carrier. Now, rule number 4 shall come into force 1 year after the date of this publication. And from rule number 3, 5 to 16 and 22 23 shall come into force as per the uh, come into force in 18 months. So just let me show you the screen of mine. This is the phases that we have divided into. Here I will not be able to I will not be explaining the rule number 17 to 21 as these rules are the obligations of the Data Protection Board of India. Basically, these rules define the structures, powers, functioning of the Data Protection Board, and these rules apply to the regulators and govern how the board is appointed, operates, and performs its functions. All other rules we will focus today apply to the organizations, entities, intermediaries, data fiduciaries. These rules define compliance obligations under the DPDPA framework. So, coming back to our rule, as rule number 1 we have explained, rule number 2 talks about the definitions. So as in DPDP Act 2023, the main terminologies that have been used here and in the act are already been explained in the definition part of the 2023 act. There are three more terminologies that are explained here, which is the techno-legal measures. Now what does techno-legal measures means? This basically means the user like for example, a legal technology means a combination of technical controls and legal safeguards used to protect personal data. Now, what does this mean is it means using a technology, policies, plus legal rules together to protect data. If we talk about the examples, encryptions and access controls are a technical controls. Policies, contracts, and compliance rules are part of the legal. Coming to the second terminology, which is the user account. So user account is an account created by an individual on a platform, system, or application to access services. Now, this what is mostly means is email accounts, banking app login, social media profile. So what does this terminology explains? Now, verifiable consent. So as you can see here, verifiable consent means a consent that can be reliably confirmed and proven, especially in cases involving children or persons with disability. Examples would be parental consent for children, guardian consent for persons with disability, identity verification before giving consent. So this is what the rule number 2 talks about. Now coming to the rule number 3, here what is the meaning of notice given by data fiduciary to the data principal? So first, let me tell you what the data fiduciary means here. Now, a data fiduciary means any person who alone or in conjunction with other person determines the purposes and means of processing personal data. So they are the individual who will define the purpose and the means of defining a particular and processing a particular data. So one data principal is none other than the individual whose data will be used to process. They can be a child, includes a parental or a lawful guardian or a person with disability. So what does this rule talks about is the notice must be independent and self-contained. What does that mean explained here? The notice must be independent and self-contained. This means it should be clear and understandable on its own without relying on any other documents or information. Second, the notice must be written in clear and plain language. So this is what I talk about. The notice must be written in clear and plain language, must provide sufficient details to help the individuals make an informed decision. This includes an itemized description of the personal data being collected and the specific purpose of which the data will be used. And for, moving forward, it talks about the notice must provide a clear communication link, must have a website or an application link, along with the available means through which the individual can withdraw, consent, exercise their rights under the law, and file a complaint with the Data Protection Board. So, most important, the process of withdrawing consent must be easy as the process of giving consent. That is what this rule number 3 talks about. Now, coming to the rule number 4. Rule number 4, here we have introduced a new terminology, which is called the concern manager. Now, what does a concern manager means? A concern manager means a person or an entity or a company registered with the Data Protection Board of India who acts as a single point of contact to enable the data principal to give, manage, review, and withdraw their consent. So they are kind of a mediator between the data principals and the Protection Board of India. Now, 4 introduces the concept of as a concern manager. The entity is enable to individuals to manage, give, review, and withdraw their consent. Now, here they have explained the part for the condition that need to be fulfilled for the first schedule. So, coming to the first schedule, yeah. So here you can see first schedule talks about the applicant is a company or that should be incorporated in India. They should have a sufficient capacity, like in terms of financial capacity, and they should have a stability. Should have a net worth of the applicant should not be less than 2 crores and should have a like general reputation and record of fairness and integrity. So these are the parts that we explain here. Now they should work in accordance with the interests of the data principles. Coming back to the our rule number 4, this is what I explained in schedule A of yeah. So coming back to rule number 4. Now these what all the fulfillment and conditions, if that is those conditions are satisfied, then the applicant will be registered as a concern manager. Here applicant means an organization, company, or entity. If that is not satisfied, there will be a rejection and the rejection will be communicated with the proper reasons that why the particular individual applicant has been rejected. Now the obligations are explained in the part B of the first schedule. So let us go again in the part B of the first schedule, which explain the obligations of the data. So coming back to the part B part, uh, here the part B explain the maintaining the consent records. So data principal using its platform should give consent to the processing of our personal data by the data fiduciary onboarded. And it also talks about the ensuring the transparency and neutrality. like preventing the conflict of interest. So these are the talk that were shall ensure that the manner of making available the personal data or its sharing is such that the contents therefore are not readable by it. So the consents given, denied, driven, withdrawn by her should have a notices preceding or accompanying request for consent and sharing of her personal data with the transfer data principals. Now, the concerned manager shall give data principal using such platform access to such records. They shall, on the request of data principal, should give in accordance with the terms and terms of the services, and that those things should be in a machine readable format. So they should also maintain such records for at least 7 years, so that such longer period as a data principal or concerned manager may agree upon or may be required by the law. Now, SK 6 talks about the concerned managers shall not subcontract or assign a performance for any of its obligations. So what here this means is they cannot like appoint someone else or a third party for the assignment and the performing on their behalf and working on their behalf for the obligations of for the concerned managers. Now the concerned manager should have a reasonable security safeguards to prevent a personal data breach, should act in a fiduciary capacity in relation to the data principal, should avoid a conflict of interest with the data fiduciaries. Now, coming to point number 11. Now, this basically shall publish in an easily accessible manner. The concerned manager should publish on a website or an app in such a way that the promoters, directors, and key management personnel, senior management company of interest are able to access it easily in a such a manner that they are able to use it and able to go through that links in an easy manner. Every person who holds the shares in excess of 2% of this shareholdings company and registered concern matter should also able to access that properly. Now, point number 12 talks about the in place of effective audit mechanism or review, monitor, evaluate, important report and the outcomes of the such audits should be also released to the Data Protection Board of the India. 13 talks about the control of the company registered as a concern manager shall not be transferred by the way of sale, merger, or otherwise except with the previous approval of the board. So these are the main things that have been are the obligations of the concern manager that have been explained in the part B of the first schedule. Now coming back to the rule number 5. Yeah. So here the processing of personal data for the provision or issue of subsidy, benefit, service, certificate, license, or a permit by a state and its instrumentees. So this is what the rule number 5 talks about. So rule number 5 is nothing but the how govern a state process personal data for the subsidies, benefits, and services. The processing must be lawful, necessary, appropriate, and must follow safeguards under the second schedule. So here you can see it has been explained in the second schedule part. Now coming to the second schedule, we will come to that part later. Now there's construed, there's a terminology defined here using public funds shall be construed. So construed means to officially interpret the meaning of a written document like a statute, contract, or a court decision using a specific legal principles and rules for the interpretation. So this is what the rule number 5 talks about. Coming to the rule number 6. Now, rule number 6 is a reasonable security safeguards. So, any data fiduciary shall protect the personal data in its possession and under its control. So, a data processor will be undertaking care, should be appointed for on behalf of the data fiduciary to process the data. So, what does a data processor means? They means any person who processes the personal data on behalf of a data fiduciary. So what are their obligations? For the security measures, the personal data should be have a encryption, obfuscation, masking, or the use of virtual tokens mapped to the personal data. Should control the access to the computer resources. Should have a visibility of accessing and having the appropriate logs, monitoring the view for enabling detection of the authorized access and investigation or remediation to prevent recurrence. Should have uh, continued processing of event of confidentiality, integrity, availability of such personal data being compromised as a result of destruction or a loss of access to. Should be able to enabling the detection of unauthorized access, its investigations, remediations, and should have a process of mechanism of retaining such logs and personal data for a period of 1 year. Should have an appropriate contracts that should be between the data fiduciaries and the data processors so that the proper liability and accountability will be decided between the two parties. Now, should be appropriate technical and organization measures that should be effective and should be considered for the security safeguards. Coming to rule number 7. Now, rule number 7 talk about the intimation of the personal data breach. So, what the rule number 7 mandates is should be have a prompt reporting of personal data breaches. Organizations must inform affected individuals without delay, should notify the Data Protection Board, and provide detailed breach information within the 72 hours. So this is what the main rule number 7 talks about. Coming to the rule number 8. Now, this is the time period for specified purpose to be deemed as no longer being served. What does mean? Data retention and erasure part. So rule number defines when the purpose of data processing is considered and complete. Now here if we come to the specified in the third schedule, shall erase such personal data unless its retention is necessary for a compliance with any law for the time being in force or for the corresponding time being specified in third law. So coming to the third schedule, let us go to the third schedule for the understanding of the what is the data retention and erasure part has been defined. So yeah, so here you can see in case of an e-commerce company or an entity that have like less than 2 crore registered users in India, they should be able to raise the data 3 years from the date on which the data principal last approached the data fiduciary. Second part, any online gaming intermediary or that have less than 50 lakh registered users in India, they should also be have a 3 years from have a detention and a deletion part of the 3 years from the date on which the data principal last approached the data for the performance of the specified purpose or the exercise of their rights. Coming to the third part, so data fiduciary who is in social media and have less than 2 crore registered users in India, they are also at the same part, like the timeline defined for the 3 years from the date on which the DP has been approached by the DF. So this is what the data retention erasure part with respect to the entities and their sectors has defined. Coming to the rule number 9. Uh, yeah. So here, what we will be discussing is contact information of person to answer questions about processing. So this is this rule requires the organizations to publish contact details of a responsible person, such as a data protection officer. DPO has to be there so that the individual's contact details can be easily accessible to the data principal or a person who is able to answer on behalf of the data fiduciary. So that is why the DPO need to be appointed. This is all a part of the compliance which has been defined here. Coming to the rule number 10, a verifiable consent. As we have seen, there is a terminology defined for the verifiable consent. So this is what broadly explained in the rule number 10, verifiable consent for processing of personal data of child. So this mandates verifiable parental consent before processing children's personal data is to be there. Organizers must verify the identity of the parents using a reliable mechanism. Those mechanisms can be having a KYC, having the understanding of their age, having the understanding of their parental, if they are parents or not. So this is what the identity of the age, identity and age will be found out. Now, identity and age or token made available verified by the digital locker service provider. So this is the way they can be able to identify if an individual is a parent, if an individual is having a legal age or not. So coming to the rule number 11. Now here what it talks about the verifiable consent for processing of personal data of a person with disability who has lawful guardian. So consent for a person with disability. Now, rule number 11 requires the verification of lawful guardians before processing a data of a person with disability, and legal documentation must be validated. So, shall observe a due diligence to verify that such guardian is appointed by the court of law or by a designated authority or by a local level committee under the law applicable for the guardianship. Now, designated authority here is section as per the sections 15 of the Rights of Person with Disability Act. Designated authority is like will be set like this. Now, coming to the second part of it, the conditions related to the autism, cerebral impulse, mental retardedness, all these things will be addressed here. These individuals and parents of these individuals will be liable for giving the consent, and DF should be able to approach them for the consent process. That is called the verifiable consent. Coming to the rule number 12, which is for the exemptions for the child data. Now, there are very certain parts defined here. Part A of fourth schedule talks about the what are the obligations of an applicable for processing of personal data of child. So coming to the this particular schedule. Yeah. So here you can see a data fiduciary who is a clinical establishment, mental health establishment, or having a mental health establishment or a healthcare professional. Now, they should be able to proceed and restrict the provisions of health services to the child by such a establishment or a professional to the extent necessary for the protection of her health. So, what here explained is these individuals should be able to restrict the processing of the information of the childs that are have the kindly have the like mental issues and have the problem of any retardedness or like impulses that have been there. So these individuals will be addressed and will not be required for having giving the consent for the processing of their data. Furthermore, what is defined here is a data fiduciary who is an allied healthcare professional. Now, conditions are there to process this. Processing is restricted to the supporting implementation of any healthcare treatment and referral plan. So, what is recommended is such professionals for the child to extend necessary for the protection of her health. For this part, the restriction is there. A data fiduciary who is an educational institute. Processing is restricted here for the educational activities of such institute and in the interest of safety of children enrolled with such institutes. So here, similarly, other parts are also explained for the infants, for the institutions that are working in the education program. So coming back to our rule number 12. Yeah. So this is what we explain here for the exemptions for the child data and how that need to be processed and need not to be processed. So as rule number 4, these are the additional obligations of the significant data fiduciaries. So rule number 13 imposes additional obligations on significant data fiduciary. This includes the annual data protection impact assessment, which is DPIA, and should have an independent audits, should have an algorithm and technical due diligence. So here you can see they have properly defined that data protection board impact assessment should have been there, an audit to ensure effective observance of the provisions of this act and rules. So as government will notify that what are the sectors and what are the organizations that are will be considered as significant data fiduciaries. Afterwards, these data protection impact assessments, the establishment of the due diligence process, the appointment of the DPO will be conducted. And they should also, as part 4 talks about, there should be a possible restriction on the cross-border data transfer. So that is also been explained here. And section of, like part 5 talks about should we have a committee constituted by the central government purpose, the central government for the purpose of this rule, and shall include officials from the Ministry of Electronics and Technology, and may include the officials of the Ministry of Department, central government. So this is what rule number 13 talks about. Coming to the rule number 14, what are the rights of the data principal? So this is a very important rule here, as most of the individuals will be data principals. And if we focus on this, the main rights are the access to the personal data, like correction and erasure, grievance redressal, and transparent response mechanism within defined timelines. So, as you can see here, they have properly mentioned details of the means using which a data principal may make a request for the exercise of such rights. That should be properly defined. Coming to the every data fiduciary and consent manager shall promptly publish on its website or app for both, like in case of within a reasonable period not exceeding 90 days under its grievance register system, to address any grievances to the data. If any data principal is having grievances, they shall be able to give them within the 90 days time period for ensuring the effective of the system and responding with such period. Now, similar to support part 4 talks about the to exercise the data principals rights, they should be able to nominate one or more individuals, which is the right to nominate part, to one or more individuals using the means and furnishing the particular required by such data fiduciary for the exercise of such rights. So this is what the all the section rule number 14 talks about. Coming to rule number 15, this talks about the transfer of personal data outside the territory of India. So this is also termed as the cross-border data transfer. So rule number 15 governs transfer of personal data outside India. Transfers are allowed subject to conditions imposed by the central government. So it has been properly explained that India is subject to the restrictions which has been raised, or which has been requirements are raised by the central government, are restricted for transferring the data outside India. Rule number 16 talks about the exemptions from Act for research, archiving, and statistical purposes. So, if 16 provides the exemptions for processing data for research, archival, and statistical purpose. Here, what the key focus is, innovation is permitted, but with privacy safeguard. Coming to appointment of chairperson and other members. So the appointment of so as we have talked about from 17 to 20, these are the obligations of the Data Protection Board of India. So we will now come to the rule number 22. Now 22 is this rule talks about the appellate tribunal. Now here, what is the appellate tribunal means? The rule talks about the appeal to the appellate tribunal, and but here, what is the meaning of the appellate tribunal? Let me explain you that part. An appellate tribunal means a telecom dispute is kind of like organization or entity, a government entity, which means they can any telecom dispute settlement and appellate tribunal established under the section of 14 of the Telecom Regulatory Authority of India. In case of any of the person having any grievances regarding the board, they can appeal to the appellate tribunal. So this shall be filed in digital form as the appellate tribunal may decide, and they should be able to appeal file with the appellate tribunal accompanied by a fee of like amount which is applicable. Whatever the amount is applicable for the application, they'll be able to do that. And these things will be able to then in such a way that they shall function as a digital office, and that is how they will decide without any prejudice or to its power to summon and enforce the attendance of any person and examine her oath, may adopt techno-legal measures to conduct the proceedings in a manner that does not require physical presence of any individual. Now coming to the and in last rule is rule number 23. This talks about the calling for information. So rule number 23 empowers the Data Protection Board to demand information from organizations and intermediaries. Now, what is the main part is here, regulatory oversight and compliance verification are built into this framework. So This is what a short description of the all the current rules that have been introduced here. Now, thank you for your patience and time. I will like to ask Swasti ma'am to carry on with the implementation part.
Sure, Divyanshu. Yeah, thank you. Let me share my screen again. Okay, so we have talked about the evolution of the privacy, DPDP evolution reading session we did, considering the important rules with the immediate things that needs to be considered specifically, right? We need to talk about certain key requirements, right, that organization must focus on. Because when we talk about DPDP compliance, most organizations think it's only about policies. In reality, it's about building operational capabilities, right? So, if you talk about particularly data inventory and mapping, and it is the biggest risk in every organization, we know that. Considering the organization's senior management or thinking yourself as an employee, senior management, or CXO level, uh, right, the designation. So, we all know that data inventory and mapping is the key requirement for every organization to focus on because you cannot protect you cannot see, right? Because most organizations don't even know where all personal data is stored across applications, cloud vendors, sheets, CRM systems, and backups. So DPDP requires a single source of truth for data, where it is, who uses it, and why it is required to be backed up or to be retained. So this becomes the foundation for everything else: breach response, deletion, consent, and audits. Secondly, purpose limitations and minimization. DPDP forces a mindset shift basically to collect only what you need, use only for what you actually you need a declaration, and keep it only as long as it is required. This must be embedded into business processes, product designs, forums, workflows, and APIs, not just written in policy. Thirdly, consent management, right? We all know about this. This is the prime focus of the operational rules. Consent management, it is not just a checkbox. It must be clear, specific, auditable, and easily withdrawable. So most organizations today have broken consent flows, and that's one of the biggest legal risks under DPDP. User rights handling. So DPDP gives users enforceable rights, access, correction, erasure, and nomination. Right. So these are the things that needs that needs an attention, immediate attention, considering yourself being at I mean being at the committee, the senior management committee, or as an employer, that how you need to pitch this for your organization, considering the consultancy services that we provide. Slide 2 talks about security, breach response, and governance pillars. Why we are talking about this? Because without security safeguards, right? DPDP is not only about privacy, it talks about security also, right? Security and governance maturity. So security safeguards, you need strong encryption, access controls, audits, retention enforcement, and deletion mechanisms. And what about breach response protocols? Because why it is required heavy penalties associated with it. We all know, right? There are levels wise penalties mentioned in this rules and the act, where the failure to notify any breach, it causes a heavy penalties also. So that is also required to be embedded in the system. And DPDP introduces it as a reality because it is no longer optional or it is silent. You must detect quickly, assess the impact, notify the DPBI, communicate transparently to users. That is the most important thing. When we talk about governance framework, so we have a picture in our mind of the leadership, right? So leadership comes into the picture. You need at least a steering committee, privacy steering committee that talks about it. And we know that considering yourself as an SDF, right? So it requires much more than that. So it depends being a data fiduciary or SDF, but at least your organization have a privacy framework. Privacy framework being followed, considering the steering committee is the responsible, accountable people assigned to it. Common gaps that we have seen in enterprises. So in our assessments, in our previous assessments across industry, right, we see same three problems everywhere, right? So the one was the fragmented data landscape. So data is scattered, no central visibility, no accountability. Secondly, older systems, yeah, legacy systems where they are not designed for eraser, consent tracking, or rights management. So even if policy says we delete, technically it often doesn't happen. So that is much more required, like whatever the policy is saying, it should be implemented in practical. So our approach talks about the end-to-end implementation consultancy also. And definitely the weak vendor governance, because most contracts today do not have DPDP ready clauses. So that means if you have vendor, right, if your vendor violates DPDP, you are still liable for that. Moving to the next slide, let's talk about the two biggest silent risks. So it is about not aligned consent flows and untested breach responses. So that's what I was talking about. That I know that the policies might say all these things, but that should be practically implemented. Either either it should be manually seen or audited internally, or it should be automated, right? So when we talk about the strategic value of DPDP compliance, definitely the privacy forward organization, they have an edge towards the customer, and definitely the churn rate is reduced, and they have a top-notch positioning in the market, right? So it has a competitive differentiation. The organizations who are looking towards it immediately, and risk mitigation that covers loss most, because your organization security posture privacy framework is improving. Not only you are actually stringent to the compliance, reducing the risk of the penalties, but definitely the improved posture considering the operational excellence. So data governance efficiency, it reduces redundancy, your environment is secure, safe, and users have, and the customers have more trust on the organization that their data is safe. So we are launching, considering those things in mind, we are launching where we have already, customers in pipeline. We have already did the gap assessment for some of our customers, right? And we are actually planning their implementation roadmap, that how to go ahead with it. So this is a priority actions that your roadmap should be covering, considering the DPDP steering committee. I mean, enterprise-wide data mapping, that is identifying your data, PII data, across all business unit systems, geographies, and centralizing it, right? Either manual or automation, through automation. We have different tools, we have partners associated. So we are into this segment. And we know that what are the challenges in mapping the data manually. So would advise the automated approach also to go ahead with it. And definitely the updated privacy notices, where DPDP aligned consent mechanisms and user experience flows are being designed, and they are being reviewed and approved, right, by the steering committee. And practical breach response drill should be done, tabletop simulation to be done, to understand that whatever written in the policy, they are actually being followed with, they can be actually followed within the system at the time of actual breach, right? And yes, so I'll not talk much about the assessing the SDF status right now, but definitely it is a requirement in the DPDP. So right now we are not looking into it, because first we are actually building the maturity of any organization, first identifying their gaps, and then building their maturity with our consultancy services. And definitely, this is the most important, reviewing the third party contracts, where all vendor agreements are being reviewed, audited, to ensure that the clauses, the liability allocation, all things are falling at the right place, and the audit rights are also mentioned in the clauses, right to audit. So as a next step, I would recommend that partner with consultants. You have your assessment done, DPDP assessment done, where the deep, comprehensive gap analysis against the requirements will be done, and the roadmap will be provided to the to your organization. Ongoing support for the policy development, process development, records development, the tabletop simulation exercises, and monitoring. KPIs are designed to monitor the system, that the policies are being being compliant, considering all the controls or not, how that can be continually checked within the system by the internal teams or the steering committee. So this is a question to all, because we all need to begin this. So we need to be ready with this. And our consulting and audit practice specializes in guiding, I mean, mid-size organization, large enterprises, small size organizations through DPDP transformation across sectors, right? Because DPDP talks about digital data. So any data that is digital, right, that needs that organization is collecting, whether it is of the internal employees, vendors, third parties, clients, right? So they come into this picture. So you can contact us to schedule your readiness assessment, and our solution team can reach out to you with the detailed approach and plan. Now, if we talk about transforming DPDP compliance into a competitive edge, we know, like, we need a strategic roadmap that we can help with you, considering you can turn your regulatory requirements into a business value. This is a 3 months journey, where we will guide you from identifying your system current maturity level. The secondly, will I mean, provide the implementation roadmap, where you have enough time to deploy the controls, integrate processes, and minimize the gaps. And definitely uh, a kind of document that talks about the risks, where you might need some more time to identify your legacy systems, and that can be targeted to a certain target date. But definitely we'll talk about the internal audit after you confirm that you are at somewhat level ready with the operationalization and implementation of the controls considering the DPDP requirements. So these are in detail phase-wise core activities. I already have mentioned that assessment and discovery of your data, right? Across people, process, and technology, mapping all data flows, life cycle stages, storage locations, and third-party transfers. Because what I am talking about the data flows, it is very important during the walkthroughs to do the gap assessment. So we start with that, and we'll be creating the documents, records of processing activities, consent management baseline, considering the rules and audit current practices. Governance framework will guide you like to build a privacy steering committee with cross-functional representation, right? Not only from IT, not only from business, but cross functions. And if required, DPO could be appointed, and data subject access rights and data principal rights workflows to be uh, I mean, to be reviewed and to be definitely making them to come up to a stage where that are actually quite compatible with the rules, operational rules, and developing a risk register and prioritization metrics. Because as I have mentioned that for any organization, it is very difficult to implement all the things where the tools, where people, where are involved, where tool solutions are involved. So a target date can be set by the steering committee during the review meetings, that how that needs to be done step by step, considering the business risks, operational risks. And documentation awareness, definitely before sharing the implementation roadmap, we will guide the internal teams with the training and awareness sessions also, to make them understand that why the organization needs it to each employee of the organization, because that internal training is must, so that each employee of the organization is aware of the things. And also after the implementation policies, procedures, the training awareness session would be conducted, and differently for C-suite executives and key stakeholders also. In phase two, we'll be talking about the deployment priorities, like how your organization needs to go ahead with respect to the user level controls, where it covers DSAR, right? Purpose limitation, data minimization controls, consent and notice mechanisms. Then maybe the data lifecycle management, that how you need to keep the data right with you for how much time, archival processes, automated deletion workflows wherever it is applicable, or manual review of the deletion workflows, right? Considering the organization's structure and environment, and strengthening access controls, logging, encryption, and backup governance, and implementing data classification and handling procedures, because it is the prime requirement that how your data is being classified and handled. And it is added advantage for your customers, for your third parties, that how you're handling the data, and have been being defined a procedure or process for it or not. Incident readiness, because we are at the verge of the zero-day attacks. Any day any incident could happen, being the stringent systems, policies, and processes. So active solutions, the proactive solutions like threat intelligence solutions, TI solutions, needs to be integrated, or it needs to be uh, considered that how your organizations are ready for the different types of attacks, considering the critical data that are being hosted on the systems. These all is governed by the governance. This all comes under the governance framework of an organization, and they also covers the third party governance, right? Because vendor assessments as per DPDP obligation, it is requirement, and updating the data processing agreements with controllers, with processors, it is a requirement under DPDP. Phase three is assurance, audit, and maturity, because if we are handholding you with the processes, policies, development, the implementation workflows, then we will be having the internal audit, so that you have an idea that from your past maturity level, how you have improved gradually, and we with an updated risk assessment tracker, and what are the things that you can plan as a roadmap for your organization, for maybe with a short-term plan or long-term plan of 30 days, 60 days, 90 days, and how you can optimize your data lifecycle processes, keep refining your retention and deletion workflows, and enhancing the monitoring capabilities, because we believe in sustenance, and for every organization it is important to establish the ongoing governance, integrate the privacy by design principles, annual compliance filings also. So these are some critical success metrics to monitor that we will advise or recommend every organization to continuously track these. That are the DSAR response times, consent tracking accuracy, right? And data security events, that how incidents are logged, how any misses, or how the events or trend analysis being done by their teams, right? The team's accountabilities and responsibilities considering the incidents, and the response time for the breach, if any breach happens. And obviously the vendor compliance status, that how the third party assessment completion rates are being tracked. So all these KPIs can be built and developed for every organization to monitor their system effectiveness. So with this, I would end the session, and hope you got a glimpse about it, like end to end, how you can start your journey with us, or with the consultants, or within your team, internal audit team, how you can start your journey from DPDP perspective. So I would open the forum for the questionnaires. Anyone who have the questions, they can come up with their questions, and we will try to answer them. So I'm reading some questions here, or some appreciations also from Stephen. Thank you, Stephen. Thank you for the appreciation. Okay.
Thank you. Thank
Uh,
you.
yeah. So definitely we'll be looking forward, right, for the association. So any question, any kind of question in your mind considering the sessions, because I know we try to cover maximum things what we can. Okay, question and answer not open. Okay, let me check technically if there is an error. Just give me a moment. Yeah. Hi, Ashana. If you can check for the Q&A, I think as per you, the Q&A is open. Otherwise, people, I think I would request people to mark their queries here in the chat box. We'll try to answer. Okay, so we have a question like from Pooja. She's asking like what are the minimum steps to comply with the act. So as we mentioned, like you can start your journey, minimum steps like the important things, your identification of the PII data, right? Consent workflows, right? DSAR, data subject access rights, documentation policies. So I would advise first you get your gap assessment done. Right, you will get to know the minimum things that you can start with the implementation roadmap that we can share with you. So we'll be guiding you as a coach in your journey to, for your organization, that how you can practically implement the things. Okay, so From Amit sir, I think we should buy certified tool, or no, there is nothing like certified tool or something like that. In-house, definitely, if you have that capability for consent management, but I would advise the things where the consent management workflows and the particular requirement of a consent is being fulfilled through a tool that needs to be onboarded or needs to be developed in-house.
Okay, thanks.
Thank you. Okay. Is the as GDPR have you uh, okay, you have in the DPDP rules. Okay, so Stephen, I'm not getting your question exactly what you're asking considering the GDPR. You can unmute yourself and you can ask. Yes, we have a repository topic. I'm not getting actually your question. If you can rewrite the question or you can unmute yourself and ask. Okay, so any other question? Stephen, if you can repeat your question or you can say over here, you can talk about it in detail. Maybe you're asking about certain document. Yes, we are actually helping. Yes, yes. Yeah, so records of data processing, right? So that will help you in building that thing, definitely. And yes, the organizations, the global organizations who are actually applicable for GDP. Yes, definitely, Stephen. We have the processes defined. We have the viewpoint defined, designed that we can integrate with your organization once we have a walkthrough with your senior management or stakeholders where we can actually integrate that design templates with your organization requirement, considering that DPTP requirements are fulfilled. Okay, I think. Thanks to all for the active participation. And yes, yes, suppliers are under scope. Yes, definitely. Their data also. Yes, yes. So, Stephen, I think I hope we answer your queries. Okay. So what I'll say, like, it's not about B2B, it's about not B2C. It's the thing like the digital data, any kind of data being processed in India, right? So B2C, B2B, if you're talking about like that, the type of data you are covering, the personal data, right? So it talks about the digital personal data.
So no, so let me ask a question. Basically, when I say B2B means like we have customers which are basically companies. So maybe we are also a company, that company is also having some company name, either it is a partnership or maybe some public or a private company. Now their PAN number or other details, like are those personal data or only specific people data will be called as personal data under this?
No, it's not like that specific personal data. So considering that B2B organizations also, right, that like you are handling, whether it is in partnership or your entity. So any data like their actual data, their payroll data, their biometric data, right? Their contract details, their logs, right? Visitor logs, CCTV, access cards, any type of digital data that is being considering in your organization, that is being captured in your organization digitally. Like their user accounts, right? B2B SaaS, if you talk about their user accounts, right? Their admin user, their vendor contracts, right? Partner data, confidential partner data.
So means company data specifically will also be considered into DPDP, or maybe when you are saying contact person will be like, for example, if you register a supplier. So as a company, they have a, GST number, PAN number, even though GST is not a maybe personal data
Yes,
maybe,
yes,
but
yes, yes. GST. Yeah,
uh,
GST is
when
not.
you say
Yeah.
personal, yeah, PAN number of company will be treated as under DPDP. So all these things, when we register a supplier, right, we use that maybe for our internal consumption only. Similarly, when we register a customer, which is B2B, that also basically we do GST number, PAN number, and other details. Definitely, there are personal contact numbers also, where, for example, salesperson or finance person contact number. So in that context, I was asking, will DPDP be applicable for that also, if we are storing those, or
Yeah.
only B2C customers, which are people whom we are storing data?
Okay. Okay, so I got your question. So that's what I was saying. Like DPDP doesn't differentiate B2B, B2C, right? It talks about when you, I mean, common B2B myths are like we don't have customers, or we have customers, but we have the employees and vendors, email, phone number, biometric photo. It is also a personal data, and it is a myth that we don't store Aadhaar or PAN. So something like that, that all comes under the digital data, and DPDP applies to all sizes, all types of business and services.
Good question. Okay, thanks.
Okay, so any other question inside DPDP you have a post? No, I think Mohan ji, I think your question is not actually the accurate one, because you mentioned DPDP is more in personal data, not business data like contracts, etc. So as we have mentioned previously, that any data like any sales, any external personal data, right, that almost always exists, right? Vendor contact persons, partner contracts, signatories, right? I mean, the sales contacts, visitor registers, so everything that comes into picture. Okay. Okay, I think thank you everyone. Thank you for your time. Thank you for your participation. Uh, this webinar would be uploaded over the LinkedIn so that you can refer the PPT and recording. So we'll be sharing this in the coming week. And thank you once again for the participation. We are ending the event. Thank you so much.
Thank you. Thank you. Thank you.
Thank you, everyone.